Hey guys, it's Key Bros. So today we're going to analyze and give our opinions on the recent debate in Hong Kong regarding whether there's actually separation of powers based on our own legal knowledge and facts derived from the Hong Kong SAR Basic Law, and also the relevant provisions in the UK, since we've studied UK public law before as well.
So some of what we say might be different from the interpretations of the Hong Kong government, but some parts might actually be similar. But anyway, we do not claim that we are experts, and we may make mistakes.
Before we start, please remember to subscribe to our channel by pressing the red button below, like the video by giving a thumbs up, and also share the video with your friends and family members.
With that being said, let's get right into the video. So first of all, let us summarize our arguments briefly. We believe that separation of powers is actually an academic concept, and while it would be useful to analyze systems of government through this mentality, there is no absolute separation of power to be found anywhere in the world, and it is also not a constitutional rule. And Hong Kong, as a special administrative region within a sovereign entity, which is China, is by definition incapable of having separation of powers internally. So while we rely on it as a concept, it is not a rule.
To allow us to adopt Mr. Justice Cheung's wisdom, he said that we should take a flexible and realistic, as opposed to idealistic, approach to the doctrine of separation of powers. And that is from the case of Luke Kar Cheung and Market Misconduct Tribunal of 2009.
So the first point of today's video is that separation of powers is merely an academic concept, and no country has absolute separation of powers. This can actually be seen in the case law Lau Kok Fai and the Secretary of Justice in 2003, where Mr. Justice Hartman says that separation of powers is a principle which is woven into the fabric of the Basic Law. But it is crucial to note that a principle can be departed from and has exceptions. And secondly, a principle is nothing but a general guideline, as opposed to being a law in itself. Thirdly, it is not a constitutional provision that can be found in the Basic Law.
As a general concept, it is seen in many different other countries. The fact that no country has absolute separation of powers informs us that it is just a purely academic concept. It is not a cardinal rule. Gittings, writing in 2013 about separation of powers under the Hong Kong Basic Law, has said that a pure system of separation of powers is not one practiced in every country which has some form of separation of powers.
So a prime example that backs up Gittings' point is the United Kingdom, flag of which many of those who oppose the government's viewpoint that we do not have separation of powers like to wave. So allow us to define what separation of powers actually means. So according to the English scholar M.J.C. Weil, a pure SOP system requires the separation of persons whereby there is no overlapping membership between the three branches of government. But obviously this is not the fact in the UK, because prior to the 2005 Constitutional Reform Act, the Lord Chancellor was a government minister, a member of parliament, and also the head of the judiciary. While House of Lords judges were literally part of the House of Lords, which is the upper chamber of the UK legislature.
Also, don't forget, in the UK, the Prime Minister is drawn from, and in fact the entire government is actually formed from the largest party in the House of Commons, which is the lower part of the UK legislature. So there's essentially an overlap between the executive branch and the legislative branch in the UK. This means when the government wins a clear majority in the parliament, for example, like recently the Tory party did back in the 2019 general elections, essentially the legislature is dominated by the government. It's just separation of powers, you think for yourselves. And also the Attorney General of England and Wales and the Lord Advocates, which is the Scotland version of it, are part of the executive branch of government, even though they have quasi-judicial roles. So again, it's the separation of powers.
So the second issue for today is whether Hong Kong has separation of powers. So first of all, let us look at what the case was before the handover. So no separation of powers was in existence before the handover, as all legislators were actually appointed by the governor until 1985, while senior government officials were given seats in the legislature until 1995. In fact, the governor's power was compared to that of the absolute monarchs who ruled England in ancient times, and this is from Norman Minors, writing in 1998 on the government and politics of Hong Kong. Apart from that, executive council members were often also LegCo members, and they still can be, according to Article 55 of the Hong Kong Basic Law, and this obviously shows that Hong Kong does not have absolute separation of powers.
Now we'll look at the situation after the handover in 1997. So in fact, right now we do have checks and balances. It may not be completely separation of powers, but it is checks and balances. So according to Article 52 of the Hong Kong Basic Law, the Chief Executive must resign if she dissolves the Legislative Council, and then the new Legislative Council still refuses to pass a budget or any other important bill. Also, in regards to judicial review, the very controversial anti-mask ban was overturned by the court because the court found it to be unconstitutional. So it is clear that in Hong Kong we do have checks and balances, but that doesn't mean the separation of powers is a cardinal rule in Hong Kong, because they're two different things. As the press handbook from the handover ceremony suggests, the Hong Kong government is based on the principle of the separation of powers, but it is not a concrete constitutional provision in itself.
While we are talking about checks and balances, we think that it is crucial to point out that the legislature and the executive are supposed to complement each other. However, in Hong Kong, currently, certain lawmakers, especially those who proclaim that they will vote against any bill just to paralyze the Hong Kong government, must ask themselves whether they are actually performing their legislative duties. Obviously, they weren't elected to throw bananas. The legislature is an arena for debate, not a theater where clowns make a scene and then refuse to respect the council's dignified status. They, through their utter disregard for their legislative duties, are in fact the ones destroying and negating the purpose of having a legislature in the first place. And that purpose was actually to provide adequate scrutiny, not irrational denial and unreasonable criticism of the government's performance of its duties.
In regards to the executive, the Chief Executive has delegated authority over both the judiciary and the legislature here in Hong Kong. As an executive-led system, the Chief Executive takes a dominant role in governance, and this dominant power is conferred upon her by the sovereign MPC. As explained by the MPCSC, or the Standing Committee, in its decision on the 2008 Chief Executive elections back in 2004. So contrary to what certain scholars suggest, the phrase executive-led has been stipulated in an authoritatively interpretive constitutional document issued by the MPC. It has constitutional significance and is now included as Instrument 21 in our Hong Kong SAR Basic Law. According to Article 48, subsection 3 of our Basic Law, the Chief Executive is to sign bills passed by the Legislative Council. And according to Article 48, subsection 6, the Chief Executive is to appoint or remove judges for all levels.
So as you can see, the Chief Executive in Hong Kong holds formal authority over the judiciary and the legislature. Powers are delegated to the other two branches of government, and they both scrutinize the executive, but ultimately they both answer to the Chief Executive, in turn answers directly to the central government. Through her appointment of judges and signing electoral bills, it is clear that legitimacy and sovereign power is delegated to and thus exercised by the Chief Executive on behalf of the National People's Congress.
The third point I'd like to make is that Hong Kong is incapable of having separation of powers in the Western sense. This doesn't mean it's good or it's bad, it's just a fact. So first of all, there's no parliamentary sovereignty concept in Hong Kong because the Legislative Council is not sovereign. The Chief Executive is the leader of the Hong Kong Special Administrative Region, or judicial or legislative power is derived from the National People's Congress. We'll refer to as the NPC for convenience purposes, through the Chief Executive. According to Article 48, subsection 1 of the Hong Kong SAR Basic Law, the Chief Executive is to lead the government of the region. And according to Article 43, the Chief Executive shall be accountable to the Central People's Government. In the West, sovereign power is derived in the representatives of the people, i.e. the legislature. Hence, the executive is only empowered to the extent which the legislature is willing to allow. This forms the basis of separation of powers, as power is allocated to different branches of government by the legislature and the constitution in tandem.
For example, in the United Kingdom, where Parliament, technically the Queen in Parliament, is sovereign, and thus legitimizes the government, or the US, where the states are technically sovereign, and they delegate power to and legitimize the federal government through sending congressional representatives. Here, in the West, SOP entails that the legislature empowers the executive, and similar scenarios are found in other Western countries as well. However, this can be contrasted with Hong Kong, where the Legislative Council is in fact not sovereign, as shown by the fact that impeachment of the Chief Executive is only a recommendation, to the Central People's Government, and LegCo in fact does not have constitutional power to remove the chief executive, according to Article 73, subsection 9 of the Hong Kong Basic Law. Thus, legitimacy and power can only be derived from our sovereign body, which is the NPC, as the chief executive is the only official in Hong Kong who is answerable to the NPC. She, through the Basic Law, is the only channel by which legitimacy and legislative power can flow from the Central People's Government to the Hong Kong SAR government.
There are actually two powers that are responsibilities of the Central People's Government. According to Article 13 of the Basic Law, Foreign Affairs, and Article 14, Defence. So these responsibilities lie with the Central People's Government because Hong Kong is not a country, but only an SAR of China. Apart from these two powers, actually, China has already given nearly full autonomy or power for our Hong Kong government, our Hong Kong bodies, the judiciary, to manage on our own.
At this juncture, it is very important to note that while we have autonomy and we have power which is delegated from the central government, this power is delegated and it is not absolute. So the Central People's Government can actually take away this power or give us more power.
From this aspect, it is clear that Hong Kong does not have the necessary environment or constitutional preconditions for Western-style separation of powers. Because the Legislative Council is not responsible for allocating power to different branches of government, the power of amendments of the Basic Law is reserved for the NPC. And this is according to Article 159 of our Basic Law. Any separation of powers or delegation of power is performed by the NPC, not by the Legislative Council, and Hong Kong is not its own sovereign or constitutional entity. Therefore, unlike the West, there's no inherent power to be found within the Legislative Council. The same thing applies to the relationship between the NPC and the Hong Kong judiciary. The final power of interpretation lies with the NPC, but the NPC specifically delegates and authorizes courts of the Hong Kong SAR to interpret their own provisions, unless interpretation is sought by the Hong Kong Court of Final Appeal to the NPC. And this is according to Article 158 of our own Basic Law. Some notable instances where interpretation was sought by the Hong Kong CFA to the NPC were in 1999 regarding the right of abode in Hong Kong, and also 2011 of the case of DR Congo and FG Hemisphere. Now remember, DR Congo is a country. The case concerns state immunity, which is overlapped with Foreign Affairs, and as we said before, Foreign Affairs is the responsibility of the Central People's Government.
Our final point of today is in regards to Hong Kong's role within the Chinese constitution. So in mainland China, the doctrine of separation of powers is actually not recognized, and many senior government officials in the mainland have actually spoken out against this Western doctrine. For example, the judiciary in the mainland is staffed with party members. The doctrine of democratic centralism, which informs the mainland system of government, entails that power must be centralized in the hands of the NPC. And this is significant because it is a necessary consideration to take into account when looking at Hong Kong's mini-constitution framework, because we don't have to attempt to fit ourselves into a Western system of government. So while we do have checks and balances, our unique position as a heavily Westernized system within a Chinese constitutional order also warrants much caution, because while we are interpreting Hong Kong's mini-constitutional order, it is very crucial to remember that the Hong Kong Constitution is in fact subordinate to and a part of the Chinese constitutional order, and we cannot neglect the characteristics of the Chinese constitutional order as a whole. This idea is actually reflected in Mr. Justice Lam's judgment in the case of Li Yixing and the Inland Revenue Border Review in 2011. He said it is unsafe to simply borrow and apply Western models of separation of powers. And also Sir Anthony Mason writes in 2007, it cannot be simply assumed that the Basic Law necessarily mandates separation of power that conforms to Western models. Therefore, we cannot straightforwardly square the circle by interpreting our Basic Law on the basis of Western constitutional principles alone. We must also take the mainland's constitutional principles into account.
So just a brief conclusion. Although Hong Kong is an executive-led system and the final authority does lie with the NPC, we do believe that the three branches should try to stay as independent as possible from each other and refrain from an overreach from either of these three into the other two. However, it also must be said that these branches, apart from being independent, should also try their best to coordinate and cooperate with each other, and should not resort to mutual hostility and throwing more bananas. Right, so thank you very much and see you in our next video. Bye.